Hello, viewers.
Today we are here
Today
with
we are
a
here
session
with a
by
session by
Advocate Shalini
Advocate
Sitaraman
Shalini Sitaraman
Menezes.
Menezes.
She'll be speaking
She'll be
on
speaking on
intellectual property
intellectual
rights
property
and IP
rights and
management
IP
for
management
startups.
for startups.
Before we begin,
Before
we
we
would like to
we would
introduce you
like to
to
introduce
our
you to
uh,
our
eminent personality
eminent
in the
personality
field of
in the field of
IP
uh,
and
IP and
management. Uh,
management. Uh,
Advocate Shalini
Advocate
Sitaraman
Shalini
Menezes.
Sitaraman
She is the
Menezes,
founder
she
and
is the
director
founder and
of
director of
SimSim
SimSim
Advisory Private
Advice
Limited.
Limited,
She is part of the
the
registered Indian
registered
patent
Indian
agent.
patent
She has
agent.
completed her
She has
education
completed her
uh,
education
with
with
LLB, LLM,
LLM
and PhD
and
in
in
finance, valuation, and
finance,
valuation
valuation,
of
and
intangibles.
valuation of
Madam has
intangibles.
experience of
Madam has
uh,
experience
with her independent
uh,
practice as an advocate,
with her
patent
independent
and
practice as an
trademark
advocate,
attorney
patent
from
and
June
trademark attorney
2014
from
till
June
present.
2014 till present.
She has a
She has a
she has a
she has
certification
a
and
certification
publication
and
in
publication
several
in
uh,
uh,
several uh,
several
advanced course on IP
advanced course
management,
on IP
which she had
management, which
completed
she had
in January
completed in January
2006.
2006,
Sorry, in November
sorry, in November
2015.
2015.
She has
She
successfully
has
settled
successfully
a
settled a
trademark dispute
trademark
against
dispute
Amazon,
against Amazon,
patent search and
patent search
filing
and
under
filing
Indian
under
Patent Act,
Indian Patent
trade prosecutions, technology
Act,
transfer and
trade
licensing
prosecution,
agreement for
technology
patent.
transfer and
And there are
licensing
lists of
agreement
it
for patent.
uh,
And there
of her
are list of
achievements.
it
So I
of her
present before
achievement.
you
So I present
our
before you
resource
our
person who
resource
will be
person
taking
who will be
us
taking
through the
us through the
intellectual property
intellectual
rights and
property
IP
rights and
management
IP
for
management
startups.
for startups.
Ma'am, I
Ma'am,
request you to
I
kindly
request
take
you
over
to
the
kindly
session.
take over the session.
Thank you.
Thank you.
Thank you, Karina ma'am. A very good morning to all the viewers and listeners. I am excited to be speaking about intellectual property rights and IP management. Without further ado, I am going to present to you intellectual property rights and IP management. While the title startups, I think it is a general overview of IP management, whether you are in academia or whether you are a startup, or even if you're an individual who is trying to handle your own IP portfolio. I think this session on IP management is going to be useful to you. So let's start with what is property. Familiar with what is property. We are familiar with the concept of ownership of property, that this belongs to me. The concept of borrowing or lending. May I borrow your umbrella? May I borrow a pen from you? Of course, you may. And this concept of ownership of property has been there since the beginning of civilized society. And as we talk about ownership of property, the concept of law also gets prominent because you cannot have property without law, and you cannot have law without property. Over the years, if you open the newspapers in the 80s or late 70s, the focus of news was tangible property. It was gold being smuggled, gold biscuits being smuggled. And if you open the newspapers now, if you do subscribe to tangible news, the primary focus of property has shifted from tangible, something that we can touch, see, hear, feel,
smell
smell
to
to
intangibles.
intangibles.
Data is what
Data
is
is what is
traded.
traded.
Data
Data
is
is
what
what
is of
is
prime
of prime
importance these
importance
days.
these days.
And to
And
just
to
put it
just
in
put it in
perspective,
perspective,
if
if
you
you
observe
observe
the
the
amount of
amount of
data being
data being
created,
created,
it
it
is
is
it is a
it is
vast
a
amount of
vast amount
data.
of data.
Every two
Every two
days,
days,
there
there
is
is
one
one
exobyte of
exobyte of
data being
data being
created.
created.
What is one
What is one
exobyte, you
exobyte,
ask?
you ask?
One
One
exobyte of
exobyte
data
of
is
data
as much
is as
data
much
that
data
was generated
that was
from the beginning
generated
of
from the
time,
beginning of
from
time,
Big Bang
from
Theory,
Big Bang
up
Theory
until
up until
2015.
2015.
So that much
So that
data
much
is being
data is being
generated
generated
every two
every
days.
2 days. And it is not just data in the sense
The
of
data
the
that you get
data that
from
you
your
get from your
experimentation,
experimentation.
it is
It
the
is the
data
data
that
that
comprises of your
comprises of your
Snapchat, your
Snapchat,
WhatsApp
your
messages,
WhatsApp,
WhatsApp
WhatsApp
forwards, the memes, the Facebook games or quizzes that you take. All of these comprise of data. And because we have so much data, there
there
has
has
to
to
be
be
some means of protecting it. And that is how intellectual property rights are created. Whatever I can do with my
so
tangible property,
whatever I can do
land,
with my
house,
tangible property,
estates, cars,
land,
and
house,
because it is the
estate,
beginning of
cars, and
monsoon in
because
Goa,
it is the beginning of
I always
monsoon
talk
in
about
Goa,
umbrellas
I
because that is at
always
the
talk about umbrellas because that is at the foremost in my
All these are
mind.
tangible
So
property.
umbrellas,
And
all these
anything I can do with tangible property,
these are
I can do
tangible
with
property.
intangible
And
property.
anything I
I
can
can
do
buy
with
it, I can
intangible
sell it,
property.
I can
I
gift
can
it,
buy it,
I
I can
can
sell
lease
it,
it,
I
rent
can
it,
gift it,
pass it under a
I can
will,
lease it,
I can
rent it,
assign
pass
it to
it under a
someone.
will,
So,
I can
in a
assign it
nutshell, whatever we,
to
however
some
flexible or how easily manipulated tangible property was, intellectual property is just as versatile, just
versatile,
as flexible.
just as flexible.
Property. Since last 4 or 5 slides,
Now,
I
in
have
a
been talking
nutshell,
about
5 slides I
intellectual
have been
property.
talking about intellectual
I
property.
will define
I will
intellectual
define
property as
intellectual property
something
as
produced
something
using human
produced
intellect.
using human intellect.
Why am I saying human intellect? Aren't we all
Why
human
am I
beings
saying
here
human
who are
intellect?
watching
Aren't
this
we
show?
all human
Who
beings
are
here who are
watching
watching
this
this show?
telecast? Yes, but I am going to introduce you to a slide
I am
which
going to
is going to
introduce you,
talk about
which is going to
strong human
talk
intellect,
about
which was in play. So anything produced using human intellect which
not
has commercial value. Two things. I need to
two
have human
things.
intellect and I need to have commercial value. And the third important thing is that even though I am talking about intangible property, I am talking
I
of
need to have human
intellectual
intellect
property,
and I need
which
to have
is
commercial value. And the
you
third
say
thing
that something
is
is
that
in my
even though
mind,
I
I have
am
an
talking of
idea in my
intellectual
mind. How do I protect that? I do not protect that idea that is in my mind, but I need to have it on a tangible, fixed
property,
medium, such as a paper, a compact disc,
third
a
important
computer
thing,
chip,
which is
a
a
recording,
compact disc,
or
a, a
USB
recording,
drive. So
or
even
a
though it is
USB
intangible
drive,
in its nature, in its essence, it has to
though
be
it is
produced on a tangible medium in order to be protected. Up further on the different kinds of intellectual property, let us have one thing clear. We often hear IP and IPR being used interchangeably. So let's draw a distinction between the two and let's see which is the correct word to be used. IP is
intangible in
intellectual
order to be
property.
protected. And IPR, intellectual property,
IPR is intellectual property right,
I
not to be
intellectual property,
confused with IP.
not to be confused with
So
IP.
IPR, which is the
R,
right,
which is the
is
right,
vested
is
in the
vested
asset
in
and it
the
is not the
asset, and
asset
it is
in
not the
itself.
asset in itself.
Again, what do I mean by that?
Again, what do I mean by that?
If I have a trademark
If I have a
or a brand
trademark
name,
or a
that
brand name,
is the IP.
that is
And the
the IP,
registration that I
and the
seek with the
registration that I
trademark
seek
office
with
is
the
the
trademark
IPR.
office is the IPR.
An idea or an invention of some sort is the intellectual property. When I
An
apply
idea
for
or
a
an
patent and
is
I
the
obtain a
intellectual property.
registration, that
When
is
I
the
apply for a
IPR.
patent and I obtain a
So,
registration, that is the
which is the correct one? There isn't a correct answer. You may
correct.
use
May
IP and
use IP and
IPR
IPR
interchangeably and everyone
interchangeably,
is going
and
to
everyone
understand
is
you.
going to
But
understand
if you
you.
want to be clear
But
about it
if you want
yourself,
to be
when you
clear
talk
about it
about
yourself,
the
when you
asset
talk
itself,
about
your
the asset
trademark or your
itself, your
patent or your
trademark or
design,
your patent or your
that is the
design,
intellectual
that
property
is the
that you're
intellectual
trying to
property
protect.
that you're
And once
trying
you
to
protect
protect.
that
And once you
registration,
protect it,
it's
that
called the
registration
ITR,
is called
the
the
right that
ITR,
is vested
the
in
right
your
that is vested in your.
asset. Talk about
So
the
let's talk
I
about the.
usually have
I usually
definitions
have
like an
definitions
extensional
like an
definition and an
extensional
intentional
definition and an
definition.
intentional
But
definition.
today I'm going to
But
stick
today
with
I'm
just the
going to stick with
extensional
just the extensional definition. What
intellectual
comprises
property,
intellectual property?
copyrights on one hand,
Copyrights on one
and
hand
industrial
and
property on the
industrial
other.
property on the other.
Industrial property is
Industrial
further
property
broken
is
down
further
into
broken down into
trademarks,
trademarks,
patents, industrial designs,
industrial
confidential
designs,
information,
confidential
geographical
information,
indications, plant
geographical
variety
indication,
protection act,
Plant
and so
Variety
on.
Protection Act, and so on.
Copyright is
Copyright
separate from
is
industrial
separate from
property because
industrial
copyright
property
is
because
the
copyright
only right
only
which does not need to
which
have
does not
any
need to have
industrial
any
application. It
industrial
is there
application.
solely to
It
protect
is there
aesthetic
solely to
and
protect
artistic works.
aesthetic and
So
artistic
I
works.
will talk about
So
copyright
I will
first
talk
and
about
then I will go
copyright
on to
first
some
and
of
then I
the
will go
major
on to some of
industrial
the
properties.
major industrial properties. But before
Further to
we
learn
go
about what
further
is
to learn
copyright
about
and
what is
what are the other
copyright and
kinds
what
of
are the
intellectual
other kinds of
property,
intellectual
I
property,
want you to take
I
a look
want
at
you
your
to take a
phone,
look
which is
at
right
your
next to
phone,
you.
which is right next to
Go
you.
ahead,
Go
take a look
ahead,
at your phone.
take a look at your phone.
Right, we never let our phones out of
Yeah,
our
right.
reach.
We let
So if you look at something as ubiquitous as your
us as
phone, you
you
have a
have a
trademark,
trade,
whether it's iPhone or
whether it's
Samsung or
iPhone or
Nokia.
Samsung or
When you
Nokia.
start it up,
When
it
you
has a
start it up,
music, a
it
jingle
has
to
a
it.
music, a
That
starting
is
music,
unique.
a jingle to
That
it.
is trademark.
That is
You
unique.
have the
That is
LCD
trademark.
screen
You
technology.
have the LCD screen
You have a
technology.
design
You
for
have
the
a
aesthetic
design for
features.
the aesthetic
You
features.
have an
You
antenna
have
storage
an antenna
structure.
storage
You have a
structure.
chip and
You have a
external
chip
memory
and
device that
external
is
memory
inserted.
device that
So
is
we
inserted.
have
So we have
a number
a
of
number
intellectual
of intellectual
properties
properties
and therefore
and
intellectual
therefore
property
intellectual
rights
property rights
associated with something
associated with
as
something as
ubiquitous and something that we
ubiquitous,
take for
something that
granted,
we take
such
for
as our
granted,
phone.
such as our phone.
So the importance of
So the
intellectual property
importance of
cannot
intellectual
be
property
ignored
cannot be
anymore.
ignored anymore.
Start
Now
with
let's
copyright,
start
and
with
I
copyright.
discussed
And I
copyright
discussed
early
copyright
on
early
because
on because
it is something
it is something
that protects literary, dramatic, musical, artistic works. Now you are aware that I don't need to have any literary, dramatic, musical, or artistic works, or cinematographic films, or sound recordings, or photographs, which I need to sell in order to earn money. So copyright is the I can write a poem, I can compose a song, I can record a song, singing and recording it in my own studio, and not release it in the world. And I can still get protection for it. Whereas the other rights, trademarks, patents, designs, and so on, are not like that. They are different from copyright in this respect. Talk about copyrights. It starts with the meaning, which means copier of words. If you go back to the days of Gutenberg, before the first printing press, how did people circulate copies of books? There was one person who wrote the book, or he dictated it and his assistant or his novice wrote down the book, such as Vedavyasa dictated the Mahabharata and Lord Ganesha copied it down word for word. So,
copyright belong to
if it
if it
was
was
in
in
today's day
today's
and
day and
age,
age?
would it
Would it
belong to
belong
Lord
to Lord
Ganesha or
Ganesha
would it
or
belong
would
to
it belong to
Vedavyasa?
Vedavyasa? It would belong to
Vedavyasa
Vedavyasa
because
because the concept was his,
the
the
story is
story
his,
is
the
his, the
words are
words
his.
are his.
The only
The
thing
only
Lord
thing Lord
Ganesha was
Ganesha
doing
was
was
doing was
copying down
copying
what
down
was
what.
told to him. Multiple copies of manuscripts were prepared. There was an original copy, either written by the author or transcribed by someone else, and then, or as and when there were more people available, they would make copies. Black's Law Dictionary. Sorry, ma'am, to disturb you. Just hold on for a minute. Ma'am, your PPT is not visible, just to tell you. And we'll just see some connectivity issue. Just your connection.
lost connection.
Internet channel. Continue.
Now,
The window picture. Capture the window. चालू आहे सर. इंटरनेट बंद चालू आहे. कंटिन्यू सांगितलं. बोलणं झालं म्हणजे पण सिस्टम
the same Wi-Fi doesn't work.
nothing is
Which one you are using?
vice principal camera. First record the and shutdown.
You can start. And we can begin.
That's okay. Shutdown the return.
Can you start in the beginning or
We continue.
चालू असं फर्स्ट को लगा शटल का खाना पूरी मतलब लेकर बैठा नहीं.
Copyright meaning
Then I can
we
type.
have black
copyright?
My full screen.
Black copyright.
The meaning of copyright is to transcript,
The meaning of copyright is to transcript, to imitate, to reproduce an original writing, painting, instrument, or any other artwork. And it is a right and literary property that is recognized and protected by law. So, what does copyright protect? Copyright protects literary, dramatic, musical, artistic works, cinematographic films, sound recordings, photographs, architecture drawings. It protects mainly original works of authorship, and the important is that it has to be manifestation, a tangible medium that it has to be recorded in. The other important thing about copyright is that it does not protect ideas. We have in copyright law an important concept known as the idea expression dichotomy. The idea expression dichotomy basically says that idea cannot be protected, but only the expression can be protected, and we have to learn to distinguish between the two. What do I mean by that? How do we do that? So, for example, if all of us were say to go out on a picnic, and all of us saw a flower and a bee that was hovering around the flower, and later on in the day we also saw the sunset. When we come back home, I design a pair of earrings that are based on the bee, on the honeybee. I also write a poem
or writes a song about it. Somebody else does a watercolor of the sunset. Somebody else does an oil color of the sunset. Somebody else writes a song about it. And all of these expressions of the two basic ideas, the bee and the sunset, all these myriad expression forms that can all be protected and that can all enjoy valid protection for life of the author plus 70 years, depending on which jurisdiction you are in. And how long the protection lasts, because different countries have different time periods that they allow for protection of copyrights. Of course, there is a minimum period that is prescribed by TRIPS, and if you are a TRIPS signatory, then you have to comply with that. But most countries tend to go beyond that minimum period prescribed by TRIPS. So when I talk about copyright, I am talking about a bundle of rights. Whenever you hear the word property, whenever you hear the word copyright, I want you to imagine a bundle of sticks with a rubber band around it. Right? And that bundle of sticks, depending on whether I am assigning or I am selling that entire work, the entire property, that entire copyright, then I'm giving the entire bundle of sticks away. As opposed to when I am merely sharing a few rights, such as I am lending it to someone or I am loaning it or mortgaging it, then I am not giving the new owner, the temporary owner, any other rights other than to either keep it in their possession or to enjoy it for a limited period of time. And so I'm only giving a few sticks away. So whenever you think of property, whether it is tangible or intangible, whenever you think of the word copyright, I want you to think of a bundle of rights. Copyright holders have the right to holders. When I say holders, it could mean the author, who is the original owner, or if the author has assigned it to someone who is a new owner, whoever the holder is, he has the right to reproduce the work, translate the work, abridge the work, revise the work, create derivative work, such as converting a poem into a song, converting a song into a play, converting a play into a movie, or converting a book into a drama, and so on. To distribute it publicly, to perform it publicly, and to display it publicly. To make copies and sell the copies. Now, a couple of slides ago, I
So it's not
mentioned about
recording?
author and owner. And why is it important for me to draw a distinction between the two? The reason is that the author,
Just hold it. This has again gone connected. I'm sorry. There's a whole lot of connectivity. Please have it.
yeah,
We cannot do it on. Actually, they have that OBS is here.
ma'am, I have another meeting at 12:30. Just to inform you. Have to rush.
Yes.
It is
Again, we'll start. You just give none.
just one second.
The distinction between author and owner is crucial because the author may be the owner or the author may give away his rights and someone to someone else who is the owner. So we have to draw the distinction. Let me tell you a story. Uh, David
David
Slater
was
was
running a
running
company,
or
or
is
is
running a
running a
company
company
called
called
Wildlife
Wildlife
Personalities
Personalities
Limited,
Limited.
and
And
he
he
was
was
trying
trying
to
to
get a
get a
picture
picture
of
of
this
this
macaque
macaque
monkey,
monkey.
and he was unsuccessful. So what he did was he placed a bunch of disposable cameras in and around this monkey's or this particular kind of monkey's favorite haunts,
And
and the monkey, this particular monkey, ended up picking up a camera, one of the disposable cameras, and out of curiosity was staring into the lens and ended up taking a selfie. And then, of course, as monkeys are wont to do, this monkey tossed the camera and went by his own work. Now, when Slater collected all the cameras, he found this amazing selfie. So he started advertising his work using this selfie. Wikipedia, on its page about this particular monkey, took that picture that belonged to Slater and put it in that. Wikipedia always has a little of whatever it is talking about. And a Slater sued Wikipedia saying, hey, this picture is mine. This is my copyright. Now, PETA, which is the Society for Ethical Treatment of Animals, sued Slater and Wikipedia saying that this monkey, we are calling it Naruto now, this monkey is the owner of the copyright, not Slater. Because this monkey is the author and therefore the owner because the monkey has not given any rights to Slater. And therefore, any copyright, any royalties arising from that copyright, or any damages that are due because of infringement of that copyright by Slater and Wikipedia belong to the monkey and therefore to PETA, who is the guardian of the monkey. This case went to court, and for a long time, it was not decided upon because of jurisdictional issues. Should it be decided in the UK because Slater is British? Should it be decided in the US because PETA and Wikipedia were both America? And finally, the court held that the copyright belongs to Slater, but some proceeds will go to PETA for protection of that particular species of monkey. So you understand that author and owner, that distinction is very crucial because when you create a work of art, who is the person that it belongs to? Who is the person who commissioned the work? Who is the person who was there any kind of paperwork that was signed between the person who commissioned the work and the artist himself? When you go to a photo studio and you get your picture taken, does the photographer have the right to display that picture in the front desk, in the front glass cabinet? Or did you sign something? Did you not sign something? Are you the owner because you paid him money to take your picture? Well, a lot of that is governed by whatever documentation is created around that work of art. And while it does not matter so much for a passport size photograph, but for any other work, if you don't want your wedding pictures to be used as advertising material by the photographer, or you don't want your work appearing on someone's website as they are the artist and you were the subject, then you should make sure that there is some kind of liability waiver, some kind of assignment of rights, and so on. In every copyright session, there is always a question is posed, that is, what happens if I photocopy someone's book? What happens if I photocopy a library book? What happens if I copy someone's
Well,
work?
every country has a fair dealing or a fair use clause,
Well,
and as long
a
as
fair
you
deal,
are not
as you are not
monitoring or you have taken permission, as long as it's a short excerpt, as long as it is used for
as long as
research
it's a
and
short
private study,
excerpt, as long
for
as it is used
education,
for
for
research and
parody
private
or
study,
satire
for
purpose,
education, for
as long
parody
as
or
some
satire purpose,
kind
as long
of
as some kind of
remuneration is provided
uh,
or permission is sought
remuneration is
from the
provided or
original
permission is
author,
sought from the
you
original
are
author,
safe,
you
but
are safe.
always go
But
back and check
always go
with
back and check with what
what
is
is
the
the copyright
copyright
situation in that
situation with
work of
that
art.
work of art. Now,
Copyright
copyright
is,
is,
like I said,
like I said,
the
the
one
one
thing
thing
that
that
does not
does
need to have
not
any industrial
need to
application.
have any
But
industrial
we are
ability.
going to talk
But
about
we are going to
the
talk
industrial
about
property, that is trademarks
the
and
industrial
patents, a
property,
little
that
bit
is
about trade
trademarks and
secrets,
patents,
and
a little
we
bit
may
about
not
trade
have time to
secrets,
go
and
into
we may
designs
not have
and
time to go into designs
semiconductor
and
integrated circuit,
semiconductor
but
integrated circuits,
maybe that is topic
but
for another day.
maybe that
So
is
let's
topic for
start with
another day.
trademarks.
So let's
Who
start
and
with
what and
trademarks.
how is
Who
it
and what
that
and how is it that
trademarks are
uh,
around? So the
trademarks are around?
earliest
So the
mention of
earliest
trademarks
mention
go
of
back
trademarks
to
go
when
back to
hieroglyphics were
when
used. We
hieroglyphics were
weren't
used.
even
We
writing
weren't
words.
even
There was
writing
no
words. There
written
was no
language.
written language, but
Excuse me.
excuse me,
But there were beer kegs
but
that were
there were
marked
beer
with the
kegs that
emblem
were
of
marked
the
with
person,
the
a wax
emblem of
emblem of
the
the
person,
person
a
who was
wax emblem
manufacturing
of the
that beer.
person who was
And people
manufacturing
knew
that
to
beer.
ask for
And
that
people knew
particular
to
beer
ask
with
for
that
that
particular
particular beer with
wax
that particular
insignia. So
wax
trademarks
insignia.
have been
So
around.
trademarks have been around. What was the purpose
That
of that
particular
trademark?
insignia
That
told you
particular
that this
insignia
beer
told you
keg,
that this
this
beer
beer is
keg, this
manufactured by
beer is
this particular beer
manufactured by
owner,
this
beer
particular beer
manufacturer.
owner, beer
Right? So
manufacturer.
it
Right? So it is going to taste like this.
this, on the other hand, this
This,
other
on the other
insignia,
hand, this
let's say
other
one was
insignia,
a
let's say
triangle and the
one
other was
was
a
a
circle.
triangle
The
and the other was a
circle,
circle.
the
The
trademark,
circle
belongs to this
trademark
other beer manufacturer, and he
beer
doesn't use as
manufacturer,
much as
and
many
he doesn't use
hops,
as
or
much
maybe
as
he
many
flavors
hops,
his beer
or
with
maybe he flavors his
fruits
beer
or
with
berries,
fruits
and
or
it's going to
berries,
taste
and
different
it's
from
going to
the
taste
triangle
different
beer
from the
owner.
triangle beer
And therefore
manufacturer,
these
and
ended up
therefore
being some
these
kind of
ended up being some
trademarks.
kind of trademarks. So
I
a
would define it
trademark, I would
as
define
a
it as
word,
a
phrase,
word,
symbol, or
phrase,
design,
symbol, or
or
design,
any combination of these
or
that identifies and distinguishes the
be
source
the
of
source
goods
of
from one party, from those
goods
of the other.
of the others.
In very simple
In
words,
very simple words,
it distinguishes
it
the
distinguishes
circular
the
symbol beer from the
circular symbol
triangle symbol
beer
beer.
from the
It says
triangle
that
symbol
this
beer.
beer is
It
different.
says that this beer
The
is
source
different.
of this beer is
The
different from the
source of
source
this
of the
beer is different
triangle
from the
beer.
source of the
And that
triangle
is
beer.
all that we need to
And that is
remember
all that you
with
need to
respect to
remember with
trademarks.
respect to trademarks.
We have
We
various, we
have
can have
various,
words
we can
such as crest,
have
we can have
words
phrases,
such as
just
crest,
do it,
we can have
or
phrases,
I'm loving
just
it.
do it,
Or you can
or
have
I'm loving
colors
it,
and a particular
or you can
script.
have
You know, the
colors
red
and a
and white
particular
of
script.
Coca-Cola
You know, the red and white of Coca-Cola
is
uh, is
so
so
unique that you
distinct
don't
and so
even know how
unique
to
that
read
you don't even
English
know how
to
to
know
read
that that
English
is a can
to
of
know
Coke.
that that is a can of Coke. You can have
The
symbols
90s swoosh,
such
you
as
can
the
have the
nine.
yellow M, and you know
You
exactly
can
when you
have the
walk
yellow
into a
M,
store with
and
a
you know
yellow M,
exactly when you walk
you
into
know
with a M
exactly
outside
the
it,
kind of goods
exactly
you're
the
going to get served inside. You know
goods
exactly what the
you're going
burger
to
is going to
exactly what
taste like. You know exactly what the
the
fries
burger
are going to
fries are
taste
going to
like.
taste like.
Therefore, the functions of a trademark is to
The
indicate where did the
functions of a
goods or
trademark indicate
services
where did the
originate from.
goods
What was
service,
the quality
what was
of
the
those goods?
quality of
You go to
those goods.
a yellow M outside it, and maybe the fries tasted delicious, or they were crisp
It
and
has a
crunchy.
yellow M out,
And you
crisp
go to
and
another
crunchy.
store which
And you go
has,
to another store which has
let's say, a Wendy's or a Burger King, and it has different kinds
let's
of
say a
different
Wendy's, and it has
quality of
different
fries, and you know
quality of
that you
fries,
prefer the
and
yellow
you
M
know
to
that you
Wendy's
will
or Burger King. And because of this, there is a demand for the product. You will go back again
and
and you
because
will
of this
ask
for the
for that
product, you will
particular
go
product.
back
And
again
you
and
will,
you will
if you don't
product,
get that particular product, you are not probably not going to enjoy any other one. And because of
and you will, if you don't get that
quality comes the brand itself, the company leveraging this as a marketing tool.
company,
And this
but
trademark therefore ends up having great value to a company. It
that your
appears
company,
on the balance sheet as goodwill,
it
and
does, and
goodwill
goodwill
covers quite a significant portion of what someone pays for
covers
a
quite a significant portion of what someone pays for a trademark.
trademark. Where do you want to be? You want to
So
be
if
at
you
the
are
top of
choosing where do
this
you want to be,
chart. You want to be fanciful, you
you
want to
want to
be
be at the
arbitrary.
top of
What you
this
do not
chart.
want to
You
be
want to
is
be
suggestive.
fanciful,
You
you
do
want to
not
be
want to be
arbitrary.
descriptive. You do not
What
want
you
to be
do not
generic.
want to be is
Because these
suggestive.
are
You
some
do not want you do is
of descriptive or
the
suggestive.
moment something is
I don't
generic or
stand out in the
descriptive
crowd.
or
I'm no
suggestive,
longer unique.
I don't stand out in
If
the
all of
crowd.
us were
I'm
we call Shalini,
no
how
longer
would we know
unique.
which Shalini are we talking
Which
about?
Shalini are we talking
Right?
about?
So the moment something is
Right? So the moment something is
and
suggestive
because there is nothing unique, it does not become a word or a mark or a logo that is going to differentiate your
is
goods
now
from
going to
those of your
differentiate
competitors.
your goods
If I
from those
sold
of your
toothpaste
competitors.
and I called it toothpaste, and you sold toothpaste and you also call it toothpaste, how would
If
a consumer know that he wants to go and buy toothpaste manufactured by you? Or
and
that
you
he
sold
doesn't like
toothpaste and you
toothpaste manufactured by you? Right? Therefore, we need to have a Crest, we need to have a Colgate, we need to
or
have
that
a
he doesn't like
Misra,
toothpaste
we
manufactured by
need
you.
to have
Right? Therefore,
Pepsodent
we
by
need
you.
to have a
Right?
Crest, we
So
need
a
to have a
person who walks
by
into a
Colgate by
market
you.
knows
We need to
that he
have a
prefers
Mesro
Misra, or
uh,
he prefers Colgate, or he prefers Colgate with salt, and so on.
walks
So
into a
you
market
need to
knows
be distinctive, you need to be fanciful, such as Exxon,
that he
or you need to be arbitrary, like a word that does not
prefers
denote what it is. So dove is a white bird that is from the pigeon family. Dove does not mean soap in any language. But if I call a bar of soap or lotion dove, then that's an arbitrary mark.
then that's
I
an
can call
arbitrary mark.
electronics as Apple,
I can
but I
call
cannot call an
electronics
Apple
as
Apple.
Apple, but I cannot call an
So
apple apple.
when you think of adopting a
Right?
trademark, you want to be fanciful, you want to be arbitrary, you want to be unique. You want to be a mark that can be represented
So when
graphically,
you think of
and you
adopting a
should be able
trademark,
to
you want it
distinguish
graphically
the goods and services of one person from
and
the other. And I have a product, and I have a trademark for
now I
it. That is, I have to have a trademark if I launch to the market. But I don't
have
need to have a very high bar of distinctiveness, of uniqueness in choosing a trademark. All I need to do is a mark that
have
differentiates my goods from those of my competitors. But
launched
patents are a whole different ballgame.
a mark that differentiates a
They
product those of my competitors.
time, the protection that is awarded to trademarks versus that is awarded to
The time, the protection that is awarded to trademarks is very different.
why that is
And
so.
we shall see in a
So
couple of
I
minutes
like to
why that
start
is
with
so.
this quote from
So
1977
I like to start
so
with
who
this
said
quote from
there is no reason
1977 by Ken Olson,
anyone
who
would
said there
want
is
a
trademarks,
computer
no
in their
reason
home.
anyone would want that is
That
awarded to
sounds,
patent want a computer in their
in
home.
those days, it made sense. The statement made sense in
That sounds,
1977 because you had
in those days, it
that
made
was
sense.
a
There's a
room
room
or
or
maybe
maybe
a
a
story and
story
a
and a
half,
half,
and
and
it was
it's
extremely
extremely complicated. You could not just feed in instructions in regular language. It had to be in machine. You had to punch out the code and so on. But if you talk to someone today, where every single person, even my vegetable vendor, has a smartphone in his hand, and a smartphone is nothing but a computer that fits in the palm of your hand. So anyone and everyone, including a 3-year-old child who doesn't know how to read yet, knows how to use a phone, right? That is, knows how to use a computer. So to that person, this statement makes no sense. So let's talk about what can be patented. Any invention relating to a product or process, it has to satisfy three criteria. It has to be novel or new. It has to be non-obvious. That is, it has to have an inventive step. What do I mean by inventive step? That means if I collect all the prior art, all the art that is there up until today's day, today's to this time, 12 or 7 p.m., and I collect all that, my invention has to be one step. You can think of a physical step going up. It has to be one step above everything that exists. And it has to be capable of industrial application. So that usefulness, novelty, and non obviousness, all three are extremely important. So, what is a patent? A patent is, in simplest terms, a right to exclude others. So, it is a negative right, a right to exclude others from making, using, selling, or offering for sale or importing the patented product. Is it a right to use the invention? No. It is a right to exclude others from using the invention. And it is a quid pro quo you have with the government, wherein you disclose your invention sufficiently to the government, to the patent office, to the person examining your patent, and for 20 years from the date of filing, you get protection for your invention. The important thing to remember is that a patent is a territorial right, right? So when I apply for a patent in India, I get protection to stop others, to exclude others from making, using, selling, licensing for sale, importing the product or process without my consent only in India. If I want such a right in other countries, I have to apply in those countries. So there is no of global patent allowed. That is an important distinction, and that is true for all of the intellectual property rights, that there is no global registration. You have to choose which countries you want to protect your invention in. Of course, there is some relaxation in terms of how much time you get for filing, and there is a sort of a mailbox process which simplifies filing fees and the documents that we need and examination and so on. But that is again for a topic for another day. In addition to being novel, non obvious, and useful, there is a subject matter eligibility that is important according to the Indian Patent Act. If you go to the US, this section 3, that what cannot be patented, doesn't exist. US says anything under the sun can be patented, including discoveries. But India does not have that. India has a number of things that we do not allow, we say cannot be patented, such as something that is frivolous, contrary to natural laws. Like if I say a perpetual motion machine I have created, that cannot be patented. Something contrary to public order of morality. So if I have an invention whose sole purpose is to steal from someone, then that cannot be patented. A mere discovery, if I'm digging a hole in my backyard and I come across a new metal, I cannot patent that because it is not a product of my intelligence. D, I have left out on purpose. I'll come to it in a second. Something that is a mere admixture. If I mix salt and sugar and I call that patentable, no. A mere arrangement or rearrangement of materials. So if I have an air cooler that sits on the ground and it has a pipe that takes out the water, that extra water into a trough. But if I now take that water cooler and stick it on the wall, and I have a pipe that carries the excess water into my kitchen drain or into my bathroom drain, then that is a mere arrangement or rearrangement with no inventive step. Method of agriculture, horticulture. India is an agrarian nation, or was at one point of time, and to protect the interests of farmers, we did not allow, and we do not allow, method of agriculture or horticulture to be patented. Any kind of medical, surgical, curative, prophylactic, diagnostic, therapeutic method of treatment for humans or animals cannot be protected. And why is that? The reason again for that is we are a socialist country, or it says so in our constitution, and we want these treatments to be available to the common man, to the person who lives in the village, and therefore to patent such a thing would be to put it out of the reach of the common man. Plants and animals cannot be patented, although they can be patented in the US. We have an example of the Harvard Onco mouse, where a transgenic mouse was patented. Uh, but there were other countries that did not allow the patenting of the Harvard Onco mouse. Mathematical methods or business methods, computer programs per se, this is a minefield which I don't, again topic for a whole afternoon. But suffice to say that we do not allow patenting of business methods. Literary, dramatic, or musical work, artistic work, cinematographic film, sound recording is not protected because it is protected by the Copyright Act. Method of playing game is protected by the Copyright Act. Presentation of information is protected by Copyright Act, and because these three are protected elsewhere, they are taken out of the ambit of patents. Topography of integrated circuits is protected by the Semiconductor and Integrated Circuits Act. Traditional knowledge cannot and should not be patented because it is something that has been passed on through generations and is either known commonly in a particular community, and therefore the novelty clause is destroyed, or it belongs to an indigenous community, and therefore to patent traditional knowledge would be to infringe on the rights of the indigenous community, and therefore traditional knowledge is not patented. We have several case laws where at some point the controller was not aware that something was traditional knowledge, such as the antiseptic properties of haldi or neem or honey and quinoa, and these were granted patents but were later revoked when proponents of the indigenous community spoke up for the rights. And of course, inventions relating to atomic energy are not patented in India for security and defense purposes. Now, you remember section 3D that I left out a couple of slides ago? Section 3D needs a separate slide of its own, which is why it's here. What it says is a new form of a known substance and a new use of a known substance cannot be patented. Again, what does that mean? So if I have paracetamol and I know paracetamol is antipyric, meaning it controls increase in temperature of human body. But today, if I realize that after a bunch of experiments, I realize that hey, paracetamol cures cancer. Can I patent paracetamol again? The answer is in India, no, because it is a new use of a known substance. Paracetamol in its known form cannot be protected as medicine for cancer. And if I also realize that now paracetamol instead of wax or instead of syrup or tablet can be available in wax form and can be applied on the body, if it does not result in enhancement of that known efficacy, that this much dosage of paracetamol cures this much fever, if it does not change that, then it becomes a mere discovery and therefore it is not patentable. So a typical patent document is quite complex. It is a techno legal document and it should be drafted by a lawyer in conjunction with the inventor. So there is a title, field of invention, background, prior art, deficiencies in prior art, summary, objectives. The figures have to be described, the description has to be in detail. Then, of course, claims, and it is in capital because the claims are the heart or the soul of that entire document. And they have to be drafted with extreme care, and of course then an abstract, and finally the figures that have to be in compliance with the Patent Act. So a typical one small case study where patents are concerned: when the first patent for a light bulb was filed by Thomas Alva Edison, he had said carbon filament. But we know that there is a hollow chamber with some gas and a filament, a metal filament. He specifically claimed carbon filament. But by claiming only carbon filament, he has let go of all the other material filaments. Had he claimed his independent claim as saying a filament and electricity, and then a dependent claim saying the filament used is carbon, and another dependent claim saying filament of any conducting material, rather than using carbon in the independent claim. So there are techniques, there are arts and crafts that are required. There is an art and there is a craft to drafting claims, and it has to be done by someone who is experienced in the field. Now, you may say, why do I need to go in for a patent? Why can't I go in for a trade secret? What is the difference between a patent and a trade secret? In very simple terms, if something is not does not give you that step that I was talking about, that inventive step, right? And which can be easily copied once it is out in public domain, then I would want to keep it as a trade secret. If something that cannot be reverse engineered very quickly, that where I have a monopoly in the market for at least 10 to 15 years, that should be patented. So, for example, Coca-Cola recipe, the moment the recipe is out in market, there will be hundreds, if not thousands, of copycats for a drink similar to Coke. But at the same time, if you look at the first television set, the one with the cathode ray tube, how many years did that technology exist before your thin screen and LED, LCD, plasma, 4K, all these came into market? More than 20 years, right? So it made sense to patent the television technology, but it doesn't make sense to patent copyright or patent uh, your Coca-Cola recipe, because the moment you want to patent something, that technology has to be published. It has to be disclosed to the government. So that brings me to trade secret. Trade secret is any kind of formula, practice, process, design, etc., etc., where which by keeping a secret, I gain an economic advantage over my competitors or over my customers. So it can be the recipe for chartreuse liquor, It can be the recipe for Coca-Cola. It can be the recipe for KFC's spicy chicken rub. It can be my customer list. It can be the process, how I conduct business. And all of these, I have to make sure that it is kept a secret, or I am doing everything I can to keep it a secret, which means if I leave it lying on my front desk, then I am not taking reasonable care to keep it a secret. I have to keep it locked, and only few people have to have access to it. So, for example, Coca Cola, the top guys, they never travel in the same airplane at a given point of time, because if anything happens to one of them, the other person still knows the secret and can pass it on to the next person that they hire. And thus, trade secret is, so there are countries where trade secret is governed by a trade secret law, but in India we don't have a trade secret law, so it is governed by means of documentation, by means of confidentiality agreements, non-disclosure agreements, and so on. Therefore, when you are reading something, when you are reading a document, before you sign, please make sure that you go through every single clause as to what is qualified as a trade secret and what are the repercussions if you breach one of them, if you accidentally disclose one of them. And make sure that if you don't understand what is given in the contract or in the confidentiality agreement, make sure that you ask someone. There are other forms of IPR, such as designs, semiconductor layout and integrated circuits, geographical indication, plant variety protection, trade secrets we've already discussed, plant variety protection and biodiversity. But since the main ones in industrial property are trademarks and patents, and to a certain extent copyright, we will not go into the other forms of IPR today. That's again topic for another day. So I think we have a number of other days where we have to come back and learn about these other topics. Now, when I am conducting business, when I have enough IP filings, I have an IP portfolio. With that IP portfolio, I have to manage it efficiently. I have to leverage it efficiently. Only then does it perform its role as an asset. Otherwise, it is merely a sink for your funds where you are filing something, you are paying filing fees, you are paying attorney fees. But if you don't manage your IP properly, then it is all a waste. So let's talk about IP management. But rather than give you an entire lecture on IP management, I am going to take a case study and explain to you what happened in that case study. And then let's think about how we can circumvent such an issue in our lives. So, the background for this IP management case study is this is a real life scenario that the scientists at Weizmann Institute under Professor Selman, they conducted research using antibodies, and these antibodies were used as carriers to target specific cancers. A former colleague provides his materials for use in the experiment, and they obtained promising results. One person files a patent application and licenses it out, and finally, the ownership of the patent is disputed, and this litigation ended up being a very expensive affair. So let's look at what happened in this case. So the objective, like I said, of the patent was to target, not of the patent, of the invention, was to target cancer cells with a chemotherapeutic drug. Sela's research group at the Weizmann Institute, they received two monoclonal antibodies from a former colleague called Professor Schlesinger. Now, the monoclonal antibodies, they bind to specific site on cancer cells. I am not going to go into the science of this, but suffice to say that one monoclonal antibody was selected for the experiment. So if I look at how the drug trial was conducted, initially I had only the drug, then I had only the monoclonal antibody, then I had the monoclonal antibody and the drug that were chemically bound, that was in experiment C. And one more thing happened where they said, let's do the monoclonal antibody and the drug, but as a mixture, like a physical mixture, not chemically conjugated. And it was noticed that A had some effect, B had some minor effect, C had some minor effect, but D had significant effect. Now, they were expecting, Saylor's group as well as Schlesinger, was expecting that experiment C, where they were chemically conjugated, would show best results. But surprisingly, experiment D was the one that where they were, it was a free mixture. They were just mixed together and they were not chemically bound. That created a synergistic effect on inhibiting the cancer cells. So this unpredicted result was the inventive step. And this unpredicted result was because of experiment D, which was suggested by Saylor's group. The monoclonal antibodies were given by Schlesinger, and the experiment that gave the inventive step was by Saylor's group. Saylor did not consider filing a patent application. And he was happy to disseminate his results, publish it in the Journal of National Cancer Institute. So they prepared a publication and showed a draft of the paper to Schlesinger. Schlesinger was also named as a co-author because he contributed the monoclonal antibody. And this paper was published in December 1988. Schlesinger, in the meantime, has discussed the results with his colleagues at Rohrer. They initiated clinical studies, they prepared a patent application, and they claimed antibody plus antibody drug mixture. And all the inventors named were the employees of the place where Schlesinger was employed. And this patent application was filed in the US in September 1988, 3 months before Saylor's journal publication. 1988 to 1994, 6 years later, Rohrer grants an exclusive license to a company called IMClone. IMClone invests $190 million in developing this cancer therapy. 1999, Aventis acquires Rohrer and the patent after a number of mergers. And there was a drug released as well, right? A drug called Erbitux. Now in 2001, so 88 to 2001, 13 years later, the patent was granted and published because pharmaceutical patents typically take a long time. There are a lot of hoops to jump through. And the US patent limited the claims to the monoclonal antibody and the drug mixture. The other territories, the other places where they applied for the patent, they applied for the monoclonal antibody only as well as to the mixture. 2002, so 14 years later, Saylor becomes aware of the patent and says, just hang on a minute. We were the people who suggested the inventive step. Therefore, the patent belongs to us, or we are the rightful inventors. So, YEDA, which is a technology transfer company for the Weizmann Institute, starts discussions with Aventis and IMClone, and there was no resolution. So, finally, they launched a case. They went into litigation, and YEDA's case was that the inventive step originated from Saylor's group. The experiment, the idea for the experiment also originated from Saylor's group, and we have all the paperwork, we have all the notebooks to support our claims that the patent specification is drawn from our draft publication, which we had shared with Schlesinger. Rohrer's case, on the other hand, was that we provided the monoclonal antibodies. Therefore, this is ours. Therefore, this patent is ours. Also, Schlesinger advised Saylor's group, and we had already discussed we had already thought about mixing the monoclonal antibody and the drug. So the court says, okay, where is your proof? Show me your lab notebooks. Show me some kind of communication between Saylor and Schlesinger. They could not find anything, so the court held that Saylor's group, that is the Weizmann scientists, are the sole inventors of the US patent. The inventorship of the patent was corrected at USPTO. YEDA, because they are the technology transfer company that protects Schlesinger's, Weizmann's group, became the owner of the patent. And there was an out-of-court settlement where royalties had to be paid to YEDA on US sales as well as outside sales, etc. So, an interesting comment was made by Judge Buchwald. Conception is the touchstone of inventorship, not the execution, conception, the completion of the mental part of the invention. Right? So the inventors are those who conceive the idea of the simple mixture of the monoclonal antibody and the drug, not the people who provided the monoclonal antibody. Merely owning the monoclonal antibody does not give you entitlement to the inventorship. And also, there was no evidence of collaboration, any kind of paperwork, contribution letter, exchange of scientific material, exchange of uh, material from Sela to Schlesinger's lab and vice versa, that said that that suggested that this could be Schlesinger's work. So I wanted to think what procedural steps could have been introduced in Sela's group and in Schlesinger's group that could have prevented this problem from arising. So take a minute, think about it. Pause the video if you need to, and come back to it. The lessons learned are: 1. Always exercise caution in discussing research results. How do you do this? You use a non disclosure agreement or you use a confidentiality agreement. Clarify your terms if you are exchanging any kind of materials, any kind of equipment for conducting the experiment. In this case, it was monoclonal antibodies. But if you are uh, lending your telescope or your lab to someone else for performing the experiment, always use a material transfer agreement. Complete an invention disclosure form to help inventors to focus. What did Schlesinger's group do here? Did they ask Schlesinger to complete an invention disclosure form? Had they done that, they would have known that Schlesinger wasn't the inventor. He wasn't the true inventor. He was only the person who provided the monoclonal antibodies to Sela's group. Had they asked Schlesinger to complete an invention disclosure form, they would realize that he does not know how to perform the experiment. Therefore, not asking your client, your inventor, to complete an invention disclosure form is is a disservice to your inventor. It helps the inventor focus. It helps the inventor simplify the invention, the inventive step, the novelty, and the non obviousness into a very simple language, which can then help you craft the claims properly to help you draft your patent specification properly. And always keep notebooks to provide documentary evidence because you never know when someone is going to doubt who created this first. So always keep evidence. Now, having talked about this case study, and that was a simple way to bring forth the importance of IP management. When you are a startup, you are going to have certain questions. So the last couple of slides these are, and we are going to talk about the questions that startups normally have and how to answer those. Now, this is a checklist, and I want you to go through this and answer these questions for yourself, right? Because each person's case is unique. Will patents facilitate venture capital investment? Do you absolutely require to have a patent registration? Because realize that patents are time and money intensive. Can patents help a startup defend itself against attacks by their rivals or competitors? Can patents help a startup stop the theft of its innovations by larger rivals? Do you have the wherewithal to stand up to larger rivals? Can the patent ensure that is, the startup's freedom to operate? Can it help a startup rapidly increase its market share? Are you going to go from 0 to 60 in 5 months? Can patents help startups form joint ventures? Having a patent or two in your kitty, is it going to help you land joint venture partners easily? Or you can get into patent pooling or patent exchange program. Will it increase the chances that your startup will be acquired because you have intellectual property registrations? Will patents help you get ready for an initial public offering? Because initial public offering is more market centered rather than invention centered. And will startups with intellectual property achieve greater long term success than without it? I mean, you have to take a look at the market and check and do a study on how many startups have an intellectual property rich portfolio versus those that have your traditional assets in their portfolio. And finally, is it going to help you launch your billion dollar empire? or is it something that you're just doing because it is trending right now? So these are the questions you have to answer as a startup. And to to summarize what we have been talking about, and to end this with some advice for you as an IP professional, for you as a startup who will require IP professionals' services. The first step, right after you start your business, right before anything else, is to see whether you have any kind of competence to manage your IP issues. And you have to be honest about this, because if you don't, or if you have the slightest doubt, consult a professional. I have seen more cases where startup founders, and of course, they are smart people, they are intelligent people, and they think that they can manage this as well. But they have jumped into that IP pool and then realize that they are not able to handle the prosecution part of securing the registration by answering each and every objection of the patent and trademark office. So, if that is the case, please consult a professional. Next, this is before you start. Then, once you start, identify every possible asset you have in your company, whether it's your customer list, whether it's your workflow process, whether it is an idea for an innovation, whether it is your materials that you have to copyright, source code that you have to copyright, or your brand name that you want to trademark. So, make a written list of this. Go through your findings. Now go through this list and see which ones are really worth protecting, because not everything, you're not going to be able to afford everything as a startup. And even if you can, I think you should be sensible about which is actually an achievable target versus which is a sink for your money. So compare the potential gain that you expect from each of it, and then decide which ones are worth protecting. Choose the right form of protections for assets. A lot of times there are, again, very prolific and intelligent startup founders, but who are not well versed in matters of intellectual property, who think that copyright should be copyright, they should go in for a copyright, or they should go in for a patent for a software or for an app and so on. So find out which ones of your assets are worth protecting, and then find which bracket they fit into. This one goes into copyright, this one goes into trademark, this one should be patented, and so on. Speak to someone or do a search for yourself to see which is best suited for which. Decide what you are going to protect and in what ways and when. The when is important, because if you're allocating budget to protect intellectual property law, property rights, then figure out which one and what one and when, because that when will tell you how much of your money is going to be tied up at what stage. Start the actual protection process. You don't have to protect everything at the same time. Figure out priority and start the process. Raise financing if you need to. And if not, bootstrapping is the best option for the initial few years. And that is the end of the session on Introduction to Intellectual Property Rights and IP Management. Thank you.
Thank you,
Thank you,
ma'am.
ma'am.
I would like to
I would
summarize, and I
like
have
to
been listening,
summarize, and I have
ma'am.
been listening,
Lots
ma'am.
of issues and
Lots
topics
of
have been
issues and
dealt
topics have been
by
dealt
madam,
by madam,
referring to the
the
point that
point that
every
every
two
two
days,
days,
lots
lots
of
of
data
data
gets
gets
generated
generated
to
to
begin with
begin with
that,
that,
and
and
there are
there are
certain
certain
tangible uh,
uh,
tangible way
tangible
of
way of
dealing with
dealing with
ideas, because
because
ideas are
ideas are
intangible.
intangible.
So things
So
have to
things have
be
to be
brought back to
brought back
or
to or
reduced to
reduced
tangible
to
way. Am I
tangible way.
correct,
Am I
ma'am?
correct, ma'am?
Yes, yes.
Yes. Uh,
Then she
then
explained
she
about
explained about
though we
though
use
we
IP
use
and
IP and
IPR
IPR
in
in
interchangeable manner,
interchangeable
but they
manner,
are
but
two
they are two
different
different uh,
things, IP
things,
and
IP and
IPR.
IPR.
She mentioned
She
that
mentioned that
example like
example like
trademark is
trademark is
your
your
intellectual
intellectual
property, and
property,
when we
and when
apply
we
for
apply
patent,
for
then
patent,
it
then
comes
it
under
comes
rights,
under
that is
rights, the
intellectual
intellectual
property
property
rights.
rights.
She took
She
us
took
through
us
the
whole understanding about copyrights, and one example was given on about that bundle of stick tied up together to explain what how much or what copyrights you own and how you what happens when you give it. Either you give the entire or you give part of it in order to explain that she gave as an example. Madam also took us through the patent rights. What are the uh, types that we can patent? That is invention, how it can be either it has to be novel or new, it has to be inventive step, it has to be capable of industrial use. She also mentioned that in US anything under the sun can be patented, but in India there are certain conditions that has been applied whether what can be termed or used as patent and what cannot be. Further, she elaborated on Section 3D. She also cautioned the startups people that you need a careful drafting. If you are filing for patent, you require professional expertise. Then uh, she gave one excellent example, live example of IP management case, and she gave us idea about how to take care to claim our rights by putting across non-disclosure agreement, material transfer agreement, invention disclosure form to maintain documentary evidences. And she has given whole long list of steps that has to be taken care and questions to be answered by the anyone who is dealing with the startups. So thank you very much, ma'am. I have earlier also heard ma'am in one of our session, and in fact the entire the crowd had learned and enjoyed the session. And today again, it was a great learning and understanding through this IP management startup. So thank you, ma'am. So I would like to formally extend you thanks on behalf of Dempe College of Arts and Science, Miramar. This is an institute, a premier institute in Goa. We would like to thank you on behalf of our principal management for coming over here and putting up a session for our students and for all our viewers. Uh, Thank you so much, ma'am. On behalf of all our team, I thank you for coming over here and conducting this session. We will close this session now.
Thank you.
Thank you, ma'am.